Welcome to this free immigration help channel. Today is May 7, 2023 and we are getting into the volume 85 of me answering your immigration related questions. I'm gonna mention as always, as I always mention in every video on this channel, I'm not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment from Alkaline Brown. Hi sir, my priority date is May 2026 and there's a correction 2016. F11. So if F11 is a subcategory for F1, priority 1, and I documentarily qualified May 2023, please can you tell me when I will get an interview date from Jamaica? Thank you. Alkaline, thank you very much for your question. So like I said, F11 is the subcategory of F1 and basically it is for unmarried sons and daughters of US citizens over 21. There's also F12 subcategory of F1 and that's the children of unmarried sons and daughters of US citizens over 21. So let's take a look for look at the visa bulletin and see what it tells us for the F1 category. We know the priority date, it is in 2016. Let's see, May 2016, and looks like right now it's showing us January 2017. So May 2016 and right now they're processing January 20. Okay, so judging by this priority date, your case should have been already transferred to the NVC. It should have already been approved by USCIS, transferred to the NVC, and I am thinking you might be already documentarily qualified. So let's take a look at the graph A now for the documentarily qualified dates, and looks like we have December 2014 for the F1 category. Basically, the immigrant visa is now becoming available for the category F1 for people who have priority dates back in December 2014. So you are in May 16 and this is December 2014. So let me do my horrible math, use my horrible math skills to do some rough calculations. So about a year and 6 months, so year and a half roughly, looks like. That's what we have, judging by what we have from the graph A in the visa bulletin. About a year and a half for the availability of the immigrant visa, which we can sort of safely estimate that right around that time you're going to have obviously the interview once your visa becomes available. Now, a few things that you can do as of right now to kind of help, and I recommend everyone do. I recommend it all the time, and whoever's watching this video, this might be helpful as well. If you are already documentarily qualified, and if you are pretty close to the availability of the immigrant visa, maybe you look at the visa bulletin and you're not sure whether the immigrant visa is available or not, what you can do is you can always submit a case inquiry, a public inquiry with the NVC and tell them that, hey, I'm documentarily qualified, looks like the immigrant visa should be available for me. Please let me know an update. I'm waiting for an interview. It has not been scheduled yet, so I just wanted to kind of get the estimation of when interview is going to be scheduled. So that's one of the things you can do. A lot of times they respond with the just a boilerplate response, really not giving you much of the information, just saying that, hey, your case is being reviewed. But sometimes they give you a little bit more information by saying something like your immigrant visa is not available yet. And then you know for a fact that it's not available yet, and then you just stay on top of the visa bulletin and get updates from this. Another thing that you can do is you can always request the expedited processing. Again, if you are close to the availability of the immigrant visa, and if you are documentarily qualified, you meet the criteria to request the expedited processing. I have the video on this channel on how to request the expedited processing. See, maybe that's an option for you. It might not be bad, and not in the sense that it's going to be bad in any way. It's just most of the times, again, because it's at their discretion, most of the times they deny those requests. So if you get denied, don't be too upset, but it's definitely worth a shot. And the third thing that you can always do is you can reach out to the local US embassy and ask them if they by any chance can give you an estimate on when the interview is going to be scheduled, because of course a lot of US embassies, they are experiencing delays still on the immigrant visas. We know it for a fact now. As of May 4, we know it for a fact, because there was a meeting, another meeting between Immigrant Lawyer Association and the Department of State. They do it like every month, every other month, and they get together, and then Immigration Lawyer Association, they ask the representative from the Department of State all of these questions that they prepared in advance. And one of the questions was basically whether or not U.S. embassies are still affected by the delays from the pandemic. And yes, Department of State confirmed that they are in fact still affected. They're still clearing out the delays from the closures caused by the pandemic. I just done a video on it. I think yesterday it might have been. It's called U.S. Immigration News Update for May 2023. So if you haven't seen it, check it out. But as far as the visa bulletin goes, you are still within those times that are shown in the visa bulletin. So for the most part, it is really the patience and finding the patience and just wait game. And I can personally relate, because I do have a petition myself that I'm waiting on. Alright, let's move on to the next one from Rekha Patel. I filed for my brother and sister F4 category May 2007. I heard if you are sister widow, their kids has no age limit. Is that true? My nephew is 31 years old. Rekha, I never heard that. I know for a fact that if a child is under 21, then of course they are what is called a derivative beneficiary. Derivative beneficiary meaning that they go as part of the application, as part of the petition, under the beneficiary. But the aging out even applies to first preference categories, where it is unmarried son and daughter of a U.S. citizen and their children. If they are over 21, then that's it. They don't fall as under the category of a derivative beneficiary. So if you can find the source, please forward it my way. I will do my research on it. But personally, I am not aware of any exemptions like that. I will say that there is a conversation to get rid of the age limit for some of the categories, but it has not been confirmed yet for any of the categories. So I'm not aware of any exemptions that exist for any of the categories whenever it comes to aging out. Even for children that have been filed for before they turn 21, which is what they're talking about, getting rid of that particular. So if you have filed for a child, or if you have filed for a beneficiary and they have a child under 21, they can't age out because the petition was filed before they turn 21. But it's not have been implemented yet. It will be really nice if it is implemented, and I really hope that it will be, but as of right now, it's not a thing. So if you can provide me the source, I will do my research, I'll check it out. The other option is not really the other option. The alternative way, or at least what is the case, the way to handle the situation is, once the beneficiary gets their petition approved, once they get their immigrant visa, once they get their permanent resident status, immediately after that they petition for their children who are over 21. They start their own basically family reunification process. So let me put this, make sure that I let you know that I addressed the question, and we're going to move on to the next one from Floyd. Hello, thank you very much for answering my question yesterday. Floyd, anytime. I really appreciate your opinion and advice. To answer your question, yes, I have received a notice from USCIS, okay, perfect, 2 years ago, that they received my I-589, but they haven't sent me any letter asking for evidence yet. I would like to mention that, along with my I-589, my lawyer sent a letter to USCIS that says that I will supplement my application at or before interview. Perhaps this is the reason why the USCIS hasn't asked me for evidence. Yeah, I think that is definitely the case. One question: can I wait and do nothing other than renewing my EAD until USCIS send me a letter asking for evidence? I am currently going through an extremely stressful period in life and would like to just stop thinking about this asylum application for about a year and focus on the more important things in life. Thanks a lot for your time and help once again. Floyd, thank you for follow-up comment and letting me know the situation. Now I understand what's going on a little bit better. So I definitely understand. It's really hard whenever it comes to asylum, applying for asylum, and if you are in that group of people that is waiting for the interview and waiting for a long time, it is really hard because you are in the air and it seems like everything you're doing, you have the question in the back of your mind, I'm doing all of this and I'm still in the air about basically me being in the United States, because who knows what they're going to decide during the interview, so far so forth. So I would definitely recommend you trying to concentrate on other things and not think about this. Just wait and let basically time unfold and show you what is happening. Whatever's supposed to happen, let that happen. But with that being said, make sure you prepare all of the documents that your lawyer failed to submit in the initial application. If you have copies of the initial application package that were sent to USCIS, go through it, compare it to the initial evidence that is required from USCIS. You can find it on the website. Just find I-589 on USCIS website, and you will see all of the initial evidence that is required. You will see that the statement is required, basically describing your situation, why you are claiming asylum. Just a written out statement. It's 2-3 pages long. I actually have a video on this channel on how to write that asylum statement. And obviously you have to find and put together all of the supporting evidence that corroborates all the information that you provide within that written statement. Of course, I just told you, to leave it alone and not think about it. But before you do leave it alone and not think about it, prepare everything that is missing at the moment from your case. That whenever, I honestly don't know how USCIS is going to go about it. They might request this full, complete package, right? The initial evidence before the interview, and they can say, hey, we will schedule your interview in 3 months. Please send your initial evidence by then, all right? Or they might say, hey, your interview is in 3 months or in a month or in 2 weeks. Please make sure to bring all your initial evidence that is missing from the case. Regardless, in whatever situation, however it's going to play out, you are going to need that written statement and the evidence that is supporting all the stuff in the written statement, aside from all the other initial evidence that is missing from the case. Once you put all of that together, and it's much better to put it all together anyway, without a lawyer, without anybody, because when you put it all together, you will know exactly what is in there. You will know exactly, you're not going to have any kind of questions, right? So for example, let's say, there were some situations that when attorneys help someone write that statement, they write a statement, attorney explains them that they need the evidence. So it is attorney basically building all of that initial evidence. And then they go for an interview, and then there's a question about something and they cannot answer it. Why? Because it is not them who built that case, it was the attorney who put it all together. Even though it's the information about them, it's still confusing. So you have definitely an advantage in that matter if you put it all together. And once you do, then just concentrate on the stuff that you have to do, that that you need to address. Just keep renewing your employment authorization document, and patience. Hope that it's going to be USCIS asylum case will be reviewed by USCIS sooner than later. And if you have any questions along the way, you're more than welcome to come back here and ask as many questions. I'll be happy to answer, because some people apologize for asking too many questions in the comments, and you don't have to apologize, guys. Seriously, however many questions you have, it's it's a blessing for me. If I can answer your question and it is helpful to you, it's a blessing for me, because Without it, I wouldn't have these videos, without your questions. All right, let's move on to the next one from Denise Tufur. Denise, thank you for another question. Appreciate it. Hi, sir. I want to ask, if my priority date gets to March 2017, what's the next step to do? Okay, Denise. So if your priority gets to, if your case have not been, if it's still with USCIS, and you get to the priority date that is shown in the graph B of the visa bulletin, that is right around time. It means that your case should be approved by USCIS, transferred to the NVC for further processing. Now, the further processing, I've made the video. If you haven't seen it, check it out. It's called NVC portal documentarily qualified. What does it mean? Something along those lines. I have posted it a few days ago. So check it out, because in that video I was able to get the real NVC portal, real login information of a person who immigrated to the United States. They already got their permanent resident card, so they're already permanent residents. So I go through the portal, I show what it means to become documentarily qualified, what kind of fees are involved, what kind of documents are involved, so you can see all of that. So once you get access to the NVC portal, and it's full access, you complete all of these steps. Once you're documentarily qualified, then you're looking at the graph A, because graph A shows you when the immigrant visas, for which priority dates the immigrant visa is becoming available. So graph B shows for which priority dates USCIS approves the case and transfers to the NVC for the next step. And then for the graph A, it shows which priority dates are actually getting their immigrant visas and basically getting their interviews. All right, so let me post this, and we're gonna move on to the next question from Bavu Patel. Sorry if I'm mispronouncing the name. Hello, sir. I found, there's more. Let's click that. Hi, hello, sir. I found your answer very helpful and think it's my time to ask such question regarding my case. I'm glad you found it helpful. Thank you for watching. I have my I-130 from the categories of LPR, legal permanent resident, filing for unmarried son or daughter, 21 or over, and my receipt date is 2019. And my case currently status is actively reviewing, and it's been over 450 days since any further update. What is the time frame for this such case, or should I expect any further update anytime soon? And it's California Service Center. Thank you in advance. Babu, you're very welcome. Thank you for asking the question. Let's take a look. Sounds like your case is still with USCIS. So let's check on USCIS website. Let's check the processing times. I'm going to use this as an opportunity to demonstrate some navigation on USCIS website. This is it, official government website for US Citizenship and Immigration Services. We're going to go to Tools, and then we're going to go to Case Status. And I'm assuming that's where you saw that it's being actively reviewed. You entered the receipt number and seen that it's being actively reviewed, which is a very boilerplate response. But we're going to click on USCIS processing times, visit page, and it will open a different page. So we're going to select I-130, and then it's going to be permanent resident for unmarried son or daughter, 21 or older. So this is going to be our category. California Service Center, let's take a look exactly how long it takes. 65.5 months. And my math skills are horrible. That's why I deal with law and not math. So let's divide that by 12. 5.4. So 5.5 years, roughly 5.5 years. Let's take a look at, let's see, so it's been 450 days. You filed in September 2019. So you are looking roughly at, let's just add, because again, my math is horrible. I'm just going to add 5 years to 2019, and we're going to get 2024. So I would say 2024, because you're in September, and plus there's another half a month, probably 2025. 2025, you're looking at probably at where your case is approved by USCIS and then transferred to NVC. But to double check that information, let's go to the visa bulletin now, because we know your category. We know that it was filed in 2019. So we know the priority date. So let's take a look and see what's going on. This is the priority date graph. The cases that are still with USCIS. So if we look at the F2B, we will see that people that have filed, that have their priority in January 2017, are just now getting their approvals from USCIS, and their case is just now transferred to the NVC. So you are about 2.5 years from your case being approved by the USCIS and then transferred to the NVC. And then at the NVC, obviously there is some more time to wait, another 2 years roughly. Looks like that's what the interviews, the immigrant visas are actually becoming right now available for people in F2B category that have the priority date in September 2015, and you're in September 2019. So again, judging by that, roughly you are looking at about 4 years. 4 years. So between 4 and 5 years, I would say. A lot of times these processing times, as you can see, this is 80% of the cases. So 20% of the cases are still processed either faster or slower. But whenever it comes to I-130, whenever it comes to family petitions, a little bit better estimation is Visa Bulletin compared to the USCIS website. Why? Because it is NVC, it is the Department of State that finalizes the process. USCIS there is just kind of is the starting point to establish their relationship, and then the Department of State with their NVC, National Visa Center, they are the ones who issue those immigrant visas basically through U.S. embassies, and they're the ones who kind of keep the track of the backlog and stuff like that. So roughly you're looking at another 4 to 5 years. All right, let me put this, and we're gonna move on to the next one from Sand Dude. Oh, I forgot to put this. There you go, before I forget. So, question from Sand Dude. Hello, can someone get visa as a... There's more. Let me open that up, sorry. Hello, can someone get a visa as a salesperson in multi-million company by them accepting resume? But the person is undergraduate. Can a company file petition for someone as a salesperson, even if the person is undergraduate? Undergraduate means only intermediate study for working visa. Sand Dude, yeah, absolutely. So it really comes down to whether or not the employer is willing to sponsor the employee in order to come into the United States and work for them. And a lot of times, if it's a big company, they already have the established process, most likely, of dealing with international workforce, with international employees. Basically, what it means is that you're sending them the resume, they do the interviews, they obviously during the the interview process, when you send the resume, they already know that right now, as of right now, you have no legal right to work in the United States of America because you're foreign, and then they have the interviews, they establish that you are who they want to hire, and they will not be able to find a substitute for as an employee here, like yourself, because you have some particular skills, particular qualifications. Maybe they like something about you, and then they sponsor you, basically filing all of the information to USCIS, filing all of the information to the Department of Labor to say that, hey, we want to sponsor an employee from another country. There is no particular requirement as to whether it's undergraduate or graduate, whatever the level of education is. It doesn't really matter. It can be a high school student with a high school diploma, as long as they have some kind of experience in the industry that they're being hired to. That should be sufficient. But it is all up at the discretion of the employer. If they're willing to enter the employment contract with a foreign, an employee who's a foreign national, then they all do it themselves, and all you have to do is just go to the embassy with the approved petition and employment contract and say, hey, I was hired by this company, and then you get your work visa and you come to the United States. But if you have any questions along the way, which hardest part is not even, applying for that visa or getting that visa. It's hardest part is finding the employer who is willing to sponsor you. But again, because it's a multi-million company, then it shouldn't be that hard. The only thing that I'm kind of thinking might be hard is because it's a salesperson position. Because I'll explain why. Because for a salesperson position, it will be really hard to justify for this company, for this big company, to the Department of Labor that they cannot find a similar talent here in the United States of America. And that's one of the things that they have to do to justify hiring someone from another country. That's what they have to go through. Unless it's some kind of, salesperson position that of some kind of goods that are not common in the United States of America. And, it's really hard to find someone who is an expert in these goods. And that's why they're hiring someone from foreign country. Maybe that's a possibility. In that case, yes, of course. But let's move on to the next one from Man Brar. Sorry if I'm mispronouncing the name. Sir, I have filed petition under F3 category of my married son and daughter on September 2010. My chargeability area is India. I lived in California. How long I wait more for welcome letter from NBC? Okay, so I'm assuming that you, let's see actually, because you're waiting since September 2010. It's a very, very long time to wait. Wow, 13 years for a son and daughter. It's crazy. Let's take a look at the visa bulletin. So we know the priority date is September 2010. We know it is F3, and we know it is for India. So India, never mind. This is graph A. I need to be in a graph B, F3. So February 10. Okay, so it's February 10 for India. So let's take a look. You are in September 2010. Okay. Wow. Okay, so you're getting really close. You're getting really close. Let's see. Right now, the USCIS, basically, if it has not been approved, I'm thinking that you probably already got approved by USCIS. But if you're not, then you should be approved really, really soon. Your case should be transferred to the NVC really, really soon, and then you should get your access to the portal pretty soon, okay? Because that's what it shows. It's for February 10. The first step, basically, this first part is being completed. The graph A, like I was saying, it represents the becoming documentarily qualified. So since we are right now in the visa bulletin in February 2010 and your September 2010, we have, let's see, February is 2, September is 9, so we have about 7 months. So within the next 6 to 7 months, your case should be transferred to the NVC and you should be getting the full access to the NVC to become documentarily qualified. And then you have roughly about a year, December 2008, February 2010, so roughly a year and 3 months, 4 months, sorry, my math is absolutely disaster, to actually get that immigrant visa after you become documentarily qualified. So I'm really sorry you have had to wait for so long, but looks like you already did most of your waiting and it's really just on the final getting there. So 6 to 7 more months and you should be moving along. Wow, I really hope that they find a way to process this much faster. This is ridiculous to wait for your child as a US citizen. This is what F3 is. Look, F3 is a married sons and daughters of US citizens. Think about it. US citizen has to wait for their son and daughter to come and be with them like a family is supposed to be for 13 years now. And still they have to wait some more. For this month, they have to wait some more. All right. Let's address the last comment for today from Alice Blay. I have a question. I'm an asylum seeker and I was applying for C8 file form for pending asylum, and that's supposed to be for free. Yes, absolutely. Since it is my first time getting my work permit. Absolutely 100%. But he's saying that they are charging 410. I hope they didn't change something else again, because it used to be free. Whether if you are in C8, if you are an asylum, if you're in a pending asylum, your initial employment authorization document application was free and all your renewals were free. Then they made it where the initial one is free, but then all the renewals you have to pay. So now, I don't know, let me double check, because that sounds strange. Let's take a look. So whenever it comes to finding the fee, there are a few things that you can do, and we will do this together so that you can see how to navigate again the USCIS website. We're going to go to forms right here at the very top navigation menu. We're going to click on that. We're going to click on all forms right here. And then we can find 765. Let's start there first because it's the page for the employment authorization document. We'll scroll down. There is a filing fee. So let's see. 410. You remember that? So there's a C5, C30, C37, C11. There is no filing biometric fee for the individuals by current former service members. No. Okay, so there's nothing about the C8 here. All right. Let's take a look at the form instructions now. This is the PDF instructions for the form I-765. And we're going to see if we can find something that says, oh, there's already C8 here. Okay, let's see. Pending asylum, withholding of removal. Nope, not the case. Not the case. Nope. So it looks like they did get special filing instructions of those with pending asylum applications. Okay, let's see. Consider. Nope. Nope. Doesn't look like it says anything about the payment here. Okay, so if you don't find the payment information here, there's another option that we can do. And this form is called G1055. And again, you can find it in the old forms. Let's see, J1055, there you go. And it is fee schedule. This is a current fee schedule that USCIS has for all of the forms that are out there. And the edition date is March 15, 2023. Right now, it is updated. So if somebody's watching this video later, make sure you're watching it the most recent edition. But let's take a look, because this should definitely have that information. We're going to scroll down to I-765. I-765, there it is. Application for employment authorization document. If filing an initial request for employment authorization under category C8, applicant for asylum and withholding of removal, and you are not subject to item 2 immediately below, then there is no fee. But if you are a Salvadorian or Guatemalan national who is eligible for benefits under ABC settlement agreement, then you do have to pay the fee. So if this is your initial application, you see now it says if applying for renewal of your employment authorization under C8, then you have to pay. Before it was free, now you have to pay. But as of right now, still, if you're in pending asylum, there is no fee. And there you go. That's the answer you can find right here in the G1055. So thank you everyone for logging in for this video. Thank you all for asking your questions. If you have any follow-up questions, don't hesitate to ask them in the comments below. Just please make sure not to put them under my comment, because if you do, for some reason, YouTube does not send me those notifications. So thank you very much for your time. Always appreciate your time. God bless, and I will see you in the next video.